Hi there, Tom Barbalet here again from Las Vegas, Nevada. I have a question with regards to the Second Amendment, and I've always found it very curious that atheists of the Pendulette school tend to poo-poo one sacred text, but accept the Bill of Rights and the US Constitution as being a truly sacred text. It's something I've always found curious, and I think in terms of my own experiences with regards to the law in the US, this really isn't the case. In fact, the whole notion of a right really means that you need to be living and in a position of, well, relative comfort in order to actually enjoy that right. And my concern with regards to firearm ownership, and in particular militant firearm ownership, is that folks that tend to take it to the utmost degree either don't actually assert it in any real or meaningful way, or end up in really sticky situations which ultimately eliminate their ability to carry out their rights in the future. I think the fellow, I want to say Lone Ridge, but the fellow whose wife and child were killed and then he spent a year in jail and then got a settlement. I mean, if that is the success associated with this kind of intellectual movement, I'm always really concerned. I'm not necessarily sure whether you're talking about militant firearms ownership in particular, but certainly the whole notion that you have inalienable rights, and here inalienable is rather curious because all you need to do is be convicted of a crime in order to lose those rights. But this notion that texts that were written, 200 years ago have some primacy in terms of the reality of kind of the contemporary American legal system and how you can actually assert your rights through that system, I've always found curious. Some background to my own experience: when I was about 19, 20, I had the very idealistic vision that I would come to this country and file a whole lot of patents on technology that I developed and continue to develop technology and live off the money that the patents provided from, obviously these amazing technology companies that were using my ideas. Unfortunately, patent law doesn't work anything like that. Here's how patent law works in practice. You have an idea, you hire a patent attorney. You don't necessarily need to hire a patent attorney, but apparently it takes a lot more time, a lot more energy if you want to deal with the patent office directly. However, you hire a patent attorney, they file a patent application. The patent application, sorry, a slight itch in my nose. The patent application, may or may not go through. You've got a long process backwards, forwards to the patent office through your attorneys at your cost and at your time. The patent is filed, and then, independently of all of this, if you out in the wild find someone who is infringing on your patent, you then have to hire a different group of lawyers, usually patent litigators, to take these people to court, and at the end of that process, you may or may not be found in favour of. If you're found in favour of, or if it's sort of out of court, you might actually get some money. But the whole process is just very long and very time-consuming and very, very far removed from the actual letter of the law. And this is really my concern with regards to considering any historical legal document as being sacred, is that the practical application of the law is always going to be the thing that, causes the problems. With regards to firearms ownership in particular, and here I'm talking about firearms ownership not necessarily with regards to defending oneself, but firearms ownership in terms of keeping the state in check. The notion here is that the contact that you would have is either with law enforcement or, in the case of extreme civil unrest, possibly the National Guard. And these are folk that are not really known for, taking a reflective, laid-back kind of view when faced with folks carrying firearms. So I guess my concern really is whilst I don't have any problem with regards to the historical or recreational legacy of firearms ownership and use, the idea that this is a philosophy, almost like a religion basically, and that you're protecting your rights and protecting freedom and all this kind of stuff seems to be so countered by the judicial system and everything that you would encounter when you tried to assert these rights, is to be, fundamentally meaningless and not really the basis for anything other than, getting together with a group of buddies and having a good laugh about these ideas. It's not really a practical life philosophy as far as I'm concerned. So my question to you is, how can you poo-poo one group's sacred texts and then hold another particularly bizarre collection of texts rather, as being sacred? Anyway, as my face seems to be itching unbelievably, I should probably cut this short. Tom Barbalet, Las Vegas, Nevada, signing out.